And I will pass it over to Fatima.
Alrighty. So we thought it might be helpful to give some context for the discussion today in terms of what AI is, how it's evolved over time, and how it really is not actually as new as some of us might think it is. As far back as the 1960s, there's been activity at the intersection of technology and art. And I think for some time, there have always been artists who have viewed technology as an actual medium for creating their art. I noticed in the chat today, someone referred to themselves as an AI artist. I hope we hear more from you during the Q&A session because I would love to know what that looks like for you. And I think it's worth noting that you're very much part of a long and distinguished lineage of people who like to play at this crossroads. Before the version of AI that exists today, machine learning was a profound area of study. And primarily what we saw growing from that area were machines that were taking mass amounts of information and synthesizing them very, very quickly to come up with certain results. So we had, a machine learning that would play chess, that could play Go, that could answer Jeopardy questions, that was beating all of the humans on Earth who were considered the best at these mediums. But that's distinctly different from the kind of AI that exists today and that is sort of dominating our collective consciousness. What we have today is not just a matter of taking out information, finding it quickly and spitting it back out, but we actually have a form of real intelligence, meaning that information is being synthesized and new data is being created by the AI. This can look like text output. This might look like image generation, music or voice generation. We're seeing a boon of task-specific tools, AI for lawyers, AI for artists, AI for marketers. I think that trend will just continue. But this is a point that's worth underscoring because I think it impacts the law in an important way. What's being created by AI is not just an amalgamation of what's already exists. It's actually considered novel information. And I'm not sure that the law knows quite what to do with that yet. Some key concepts worth glossing over just to make sure we're all on the same page. I already sort of talked about creativity and AI and what the landscape looks like. Prompts are involve some artistry, some science. It is the information that you input into an AI machine in order to get something out. Scraping and AI data tools. This is the idea that AI models are trained by taking enormous amounts of data for which they may or may not have permission to access in order to make up the logic models underlying the AI machine itself. Generative models, fine-tuning. This is the idea that you can take an AI and give it very specific information to train on so that it's good at a particular thing. And then ethical and legal considerations, which is we see this really transforming, this technology really transforming the way that we work, the way that we create, the way that we interact with one another. And I think Anavi and I are both highly interested in what the long-term legal and ethical implications of that are. So some relevant legal frameworks, very briefly, we'll just touch on what are we talking about when we say IP? Basically, it's anything that is of value that's intangible. So creations of the mind, if that is something that's considered an invention, that would fall within the realm of patents. Art and software are covered by copyright under the law, and trademark, we're talking about branding. There's also the realm of trade secrets, which we won't talk about much, although it's still really, really relevant to today's discussion, that has to do with keeping certain business processes proprietary and secret. But one thing I'll note about this slide is that there's an inherent tension in the world of technology versus the world of law, because the world of law likes to put things in very discrete buckets, as you can see. And the reality is, particularly when it comes to some of these paradigm shifting technologies, things don't necessarily fit squarely into those buckets. And so much of what you'll be hearing us talk about today is how the law is really struggling with how to conceptualize some of what's happening and fit it into the pre-existing framework of legal categorization. Briefly, I'll talk about how we think about AI and IP intersecting. One thing to note, those of you who use AI know this, that it's not simply a matter of putting information into a prompt and getting something perfect out, that in fact, there's a real meaningful back and forth between the user of AI and the AI itself. And that, in my opinion, looks very much like a creative process that is not necessarily the opinion shared by other legal scholars and probably not by particular legal institutions. But I think there's a possibility that that may mature and evolve over time. Creation and ownership, there are there are legal implications for how, for example, artistic works are created. If they are created using AI, that can inhibit your ability to protect your work using traditional legal mechanisms. Art and innovation, I think we've touched on that. Identity and rights of publicity, this idea that you can use AI to create images of humans that look like celebrities that may be doing things that the celebrity doesn't necessarily endorse. What are the legal implications of that? And then, of course, there's this whole emerging area of law on training data and what AI can use to train its model. So a quick example here, as I was talking about the interactive nature of AI and of generating IP with AI, you can see that this text here in purple is what I put into Midjourney originally to develop some images. I then added this text in pink, and this is just meant to illustrate how there really is a conversation going on between me and Midjourney in creating what could be perceived as intellectual property. And then quickly, what do we know about how the law is treating AI so far? We have some important offices that have taken strong and sort of firm stances on how to treat AI. I'll actually start with the US Copyright Office. They say quite firmly that if AI touched a part of a creative work that you seek to register with the Copyright Office, then that portion of the work cannot be protected. So for example, if you write a play and you use AI to help you edit the first act, it's very possible that under existing copyright law, you would not be permitted to protect that with a copyright registration, which would make it very challenging for you to enforce your rights as the creator of that work moving forward. The US Patent Office has a slightly more nuanced take, acknowledging that give and take, that back and forth between human and AI and in the development of something. The position they've adopted is the only way you can protect something through patent, an invention that AI has touched, as if the human has provided the overwhelming creative input for the generation of this invention. We don't quite know what that looks like. We don't quite know what that means yet. Case law over time will surely clarify that. But you can see overall, the takeaway here is if you use AI, there is at least a risk that you will not be able to protect your work through traditional legal means, which would have implications for how you can enforce your rights, which may have an impact on how you monetize your rights. And I'll hand it over to you, Anavi.
Yes, and then so these are a lot of regulatory bodies in the government have taken stances and investigations on the current impact of AI on the creative economy. The as Fatima mentioned about the US Patent Office and Copyright Office, like they've taken clear stances. The Federal Trade Commission does a lot, and it usually protects consumers and promotes fair competition. They have interestingly been taking more of a side to protect creative rights over AI. And they've been holding roundtables ever since 2023 and doing a lot to just make sure that artists' rights and the creative economy is able to continue in this new era. So that is something that we'll continue to monitor. Next slide, please. And no pun intended, but AI has generated a ton, and I mean a ton of litigation. There's so many issues that have come up, but copyright infringement has been one of the leading ones, and a lot of other issues have been brought in these cases, such as trademark disputes, rights of publicity, image and likeness, privacy and consumer protection, trade secrets, and fair use tends to be a big defense from AI companies. And we're going to dive into some specific case studies next. Next slide. So there's ongoing litigation on multiple disciplines, but for today, given the limited time we have, we're just focusing on art, music, and writing. These are the cases that have been ongoing for a while and will be coming to major decisions in the fall. And even though they're focused on these three disciplines, they do have a lot of implications for other disciplines such as designing, video games, actors. Everyone is going to be impacted by the decisions in these cases. And just to give a quick overview, the Thaler v. I didn't pronounce that right, but Thaler v. Promoter case, it originated in 2019, where the US Copyright Office denied registration for an AI-generated visual work titled A Recent Entrance to Paradise by the creator Stefan Thaler. And he asserted that his work was autonomously created by an AI algorithm known as Creative Machine that he created. And the Copyright Office and the DC District Court were firm in that his work was not copyrightable. He has since then appealed, claiming that he had enough human involvement in the process and is still trying to get this copyrighted. So that, I believe, is set for oral argument in September or sometime in the fall. And it is something that a lot of lawyers are continuing to monitor to see what the outcome is, since it will have a lot of implication for creative rights. Another big one is the class action in Anderson v. Stability, where a bunch of artists sued Stability AI, which is one of the primary companies like for Midjourney and a ton of other image producing platforms for copyright infringement of work that was online and without compensation to the artists. So a lot of famous artists, even one of the artists who creates for Marvel, her work was the data from her artwork was scraped by AI training models and is one of the people in this class action. We will continue to see developments in that case through the fall, which will also have a lot of implications. In music, there's been a ton. Music has been like the big giant space where we've been seeing copyrighted songs, literal copying of lyrics made by AI models and used in commercial purposes, which has been very exploitive and extractive of original human creators. And some of the big ones that a lot of lawyers are monitoring are Concord Music Group versus Anthropic PBC. And one of the big ones that happened this summer was the UMG recordings. Basically all the major record labels, Sony, and a ton of others sued Uncharted Labs, which created Udio and Suno. And one of the really interesting ones that I found was, I mean, everyone knows about the beef between Kendrick Lamar and Drake. And if you don't know, Drake in one of his diss songs used AI-produced voice mimics of Tupac, and his estate sent a cease and desist letter under the basis of image and likeness and use of his publicity image, that it was done without permission. So cease and desist letters have been rampant in this time, and we will continue to see how this affects the music industry through the fall. And then in writing, if you haven't heard, the major journalistic companies, the New York Times, Chicago Tribune, a ton of journalistic companies are suing Microsoft and OpenAI for direct plagiarism of literature and previous works. So that case is going to have a lot of implications for writers, poets, and many more disciplines. Fatima, is there anything you would like to add?
One thing I'll note that's interesting, particularly about the New York Times case, is I think it highlights um, how challenging it is to reach legal consensus when the judges in the positions to make law on these cases at the moment don't necessarily have a firm grasp on what the technology is. So part of the reason that we're detailing cases right now, pending litigation, is because we don't necessarily have a ton of legislation from which to draw a lot of guidance. And the likelihood that we will, given the fractured state of our legislature right now, suggests that it may be a long time before we get a comprehensive framework of legal guidelines. And so judges are left in this challenging position where they have to make decisions on a case-by-case basis on new technology based using old law, applying old precedent that doesn't exactly provide a neat fit. And it's creating a lot of confusion among the courts. In the New York Times case specifically, the fact pattern is that we've had individuals who've been able to prompt AI to generate written materials that are actually identical to articles that were published in the New York Times, suggesting that there's actual plagiarism going on here. We're working on the presumption that everything that's synthesized and created through AI is new intellectual property, and yet skilled users of AI have the ability to basically reverse engineer art and work that has already been made by living people. So it sort of showcases some of the complexity facing some of these judges right now, and also the very patchwork nature uh, of the law as it stands right now regarding AI.
Next slide. Okay, some key legislative developments. There's a ton of pending legislation and legislation that's being drafted around AI, specifically the ones that impact creatives. There's a ton, but I highlighted a few. Most of you have probably heard by now, and if not, the Elvis Act in Tennessee. Tennessee was actually the first state to pass a law that intentionally protects the rights of musicians. And it recently came into effect on July 1st, this summer. And the main issues that it is protecting is that the main thing it's doing is that it's protecting against the unauthorized commercial use of someone's likeness by adding voice to the realm it protects in existing state law. So it also, and one of the things that makes it so powerful is that it gives cause of action for criminal and civil lawsuits. So this has been a great win for musicians and voice actors and anyone whose voice has been used in AI training models. It isn't perfect. It has created some concerns around it being, or there is a lot of concern around it being too broad, and it has brought First Amendment implications, but it is in effect, and we'll continue to see over the next coming months how it helps musicians and other artists, and we have yet to see if other states will take a similar approach. The US Senate introduced the Copy Act on AI transparency on July 11th. So this was recent. It's pending. And it is also intentionally seeking to protect the rights of journalists, songwriters, and other creatives. So we will see the impacts of this over the next coming months into the fall and throughout the next year. The US House also introduced No AI Fraud Act in January 2024. It's still pending. It's been in the legislative works for a while. And in the next coming slides, I'll talk a little bit more about how artists can get more involved in the perspectives being taken into these legislative actions. Adobe has proposed federal anti-impersonation, the Federal Anti-Impersonation Right Act. This isn't actual law that's that's pending in front of Congress, but it is making recommendations. Adobe is making recommendations to Congress, and it's interesting because Adobe, being a big tech company, is actually trying to support artists and in their recommendations, but that creative rights should be prioritized and that human creation should be prioritized in the decisions made. So it will be interesting to follow their advocacy and see how their recommendations impact legislation. I won't dive into too much into the international developments, but at least for lawyers, I have been researching what has been going on in other countries just because it's helpful for trends, patterns, and to see push and pulls. Because even though the US legislature and Supreme Court, a ton of government bodies have said that international law will not impact legal decisions here in the US, I still think it's relevant information because there really has been a global movement of artists organizing for their intellectual property rights in this era of AI, you know, all the plagiarism that's going on and the implications for creative ownership. So we've seen primary developments in China, Japan, the EU, UK, South Africa, and Saudi Arabia, just keep in mind. Next slide. Okay, so now how does this come down to like what artists can actually do? There, since there's so much going on and the law and legislature are slow to keep up with technology, we have come to this recommendation that business strategy tends to be a good way for artists to protect their rights and to protect their work. Because when thinking about a traditional business analysis and like SWOT analysis that applies when you're creating your business, especially for creatives that have been monetizing their work for a while, what do you usually do in a SWOT analysis, right? You think about finding your marketing niche, your competition, and like what are areas that set you apart. And so to put things in perspective, business SWOT analysis still applies with AI. I see AI as just a competitor and something to just now analyze in terms of what aspects of my creation, like as an artist, the things that I've been working on for years and the experiences that go into my work, what about my work makes me unique that even with AI doing its thing, and you know, AI does bring a lot of positive things also to business development. So I think that's what's helped me as an artist not feel so panicked with what is going on and feeling like I'm going to go out of business. Plus, authenticity and branding is always going to be important to people. And we also want to encourage folks to negotiate their contracts. A lot of times artists don't engage in negotiating, and there are resources out there that help you put into your contracts that your work or data from your work is not going to be used for AI training models. And with the follow-up email that we'll be sending, we have a list of resources that can help you with templates and other legal resources that you can utilize if this is an area that you feel that you don't have enough information on. Fatima, did you want to talk about establishing an IP strategy?
Yes, thank you, Anavi. And just a couple of comments about this idea of how AI impacts your design of a business strategy with regards to your art. The way I tend to think about it is there are kind of three buckets of considerations that AI touches. One is how artwork is generated. The next is how artwork is protected. And the third is how artwork is monetized. And each prior point impacts the next. So if you generate artwork using AI, the likelihood that you'll be able to protect it is low. And if you can't protect it, it's very challenging to monetize it, because protecting it, getting a copyright registration is what allows you to say, this is mine. These are the outer boundaries of what I created. I have a US registration number attached to it. This is what I'm contracting around. Protecting your artwork is important, even if you don't intend to monetize your artwork, because it is part of preserving the artistic integrity of your work. And so that's worth keeping in mind as well. But all that said, you know, these are considerations that artists have always had to make with regards to their work. AI adds a particular new dimension to the consideration, but these ideas of distinguishing yourself through authenticity and branding, negotiating strong contracts, using whatever leverage you have to give yourself strong terms in your agreements, and giving yourself opportunity to re-up and renegotiate, and establishing an IP strategy, deciding to what extent you're going to legally protect your branding, legally protect the work itself, how are you going to contract around those units. These are all considerations that have always been relevant to artists, particularly artists who seek to make a living off of their work. So there's lots of information from the way that law has always been practiced that's still relevant to you. AI is just adding a new dimension of considerations to that.
And lastly, there are other practical tools. There is defense technology being developed, specifically for artists. Nightshade and Glaze, which has been developed by the University of Chicago, are technology defense tools that have helped artists basically coat their work that goes online in a way that prevents AI from scraping data and mimicking their artwork. So those are resources that are also included in the resource handout that we will be sending in a follow-up email. And then the Authors Guild has a really great resource page that gives tips and best practices for protecting your writing, and even highlights technology that helps prevent AI bots from scraping your website. So those are also included on the resource list. And then finally, collective action. So this is actually the time and place where artists' voices are needed. There is ongoing legislation. A lot of the federal government regulatory bodies have had comment sessions where they want to hear from artists to know what is going on and like what concerns artists have. And we know a lot of times capacity, especially for entrepreneurs, like trying to develop their business, do their work, there's so much going on. But if you feel that capacity is an issue for you, we recommend joining artist advocacy organizations that are doing all of the heavy lifting of tracking bills that impact artists, and then they usually send out information through listservs on direct action items that you can take, whether it be submitting a letter or direct comment. I've been working in legislation for the past 5 years prior to my current role, and I have seen firsthand how constituent voters, everyday people, like when they actually do engage in this process and communicating with the representatives, it actually does have an impact on the way that a representative votes. So if there's any hesitation on that, I'm here to encourage you that like definitely voice your concerns and call your reps and submit those comments and send those letters, because there's so many decisions being made on legislation over the next year and ongoing. And right now, really well-funded AI companies are lobbying in Congress, and we don't really have enough artist voice balancing that level of advocacy that AI companies are doing. And with that being said, the last item I'll say, if you are in a position where you feel that your rights have been, or that your copyrights have been infringed, class actions, from what I've seen in the research, have been more beneficial to artists, because when you have just one plaintiff, it's really hard to go up against these like very rich AI companies. And so in the resource page that we have, we also included law firms that are doing class action suits on behalf of creatives. With that, I will hand it over. Well, we hope this was helpful. Feel free to bring any questions. I know we didn't quite get to a Q&A, but feel free to bring those into your consults, and I will hand it over to Hope.
Oh my goodness. Thank you so much, everyone, for participating. Thank you so much to our presenters, Fatima and Victoria. You all are incredible. I'm going to stop the recording right now. And